Good afternoon. My name is Michelle, and I would like to welcome you to the Eversheds Sutherland Webcast, a primer on private BDCs. I'm joined today by Eversheds Sutherland's attorneys Cynthia Cruz, David Roby, and Kristen Burns. We'll start with a few housekeeping notes. If you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. After the presentation, if you'd like to request a copy of the slide deck, please contact any of the speakers. This webcast is being recorded, and the final version will be posted to www.publiclytradedprivateequity.com within the next few days. CLE credit is approved for this webcast in California, Georgia, New York, and Texas. CLE credit is pending in Illinois and Virginia. Reciprocal CLE credit may be available to attendees licensed outside of these states. Please check with your respective state bars for confirmation. If you'd like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And now I'll turn the presentation over to Cynthia Cruz, Executive Partner at Eversheds Sutherland.
Good afternoon, everyone. We're going to talk today about private BDCs. We're going to try and give you a little bit of a definition of them. First, we're going to start with talking about just the different forms of or structures there are for BDCs today. We've got the traded BDCs or listed BDCs, which I think most people are familiar. They're traded on the markets. They're very much like a closed-end fund. And then you also have the non-traded BDCs. And the non-traded BDCs are not listed. They're basically sold through the independent broker-dealer networks. And then we have the newest version or structure that we've been dealing with, which is private BDCs. It's a little bit of a misnomer because private only indicates that the money is raised privately, but it is a publicly reporting entity. So one of the reasons we're here today to talk about BDCs is because of the fact that they are very resilient and they morph over time. Just to give you a little bit of information about the history of the BDCs, BDCs have been around obviously since 1980, but they really made their way into the public mindset around 2003 when the Apollo transaction was accomplished, and it was one of the first it was one of the first externally managed structures as far as the newest crop. And then in 2008, Franklin Square was the first non-traded, and then TPG in 2011 was the first private BDC. And as you can see at the bottom of the page, the private BDCs have become one of the more constants in the newly formed IPO capital raising market. And you can see today, this just gives you a little bit of an idea. There's 92 BDCs today. 52 of them are listed, and then 19 are non-traded. And with the BDCs that are private, there's over 20 of them on file. And they've only been around, again, since I mentioned in 2011. So they've definitely become very important. And then when you look on to page 6, which I've got here, you can see since 2016, really all the newly formed entities that have been raising capital have been doing it primarily in the private BDC space. And the only listing or IPO that's occurred since 2016 is the TCG, which is the Carlyle Group. So we thought it was time for us to spend a little time discussing what it means to be a private BDC. And so we're going to run through those slides. If you have any questions, please write them out, and we'll try and answer them as we go along or at the end of the program. So, Kristen, I've been using the term private BDCs, I'm bantering it around. What does that really mean?
A private BDC is a hybrid between a private fund and a traditional BDC. It's like a private fund because investors are solicited through the private placement process, and they generally make a capital commitment to the BDC. However, the entity that they're investing in is similar to a traditional public BDC.
So, but how do shareholders get any liquidity if it's private?
The terms of the private BDC contemplate generally a liquidity event after a set period of time, and if there's not a liquidity event, the BDC would wind down.
And that comes almost from the non-traded structure. So there's been the private BDCs borrowed concepts from both the listed as well as the non-traded.
Exactly.
And then so outside of the capital raising, do they have to go by all the requirements of the SEC, any other reporting company?
Absolutely. Outside of the capital raising, they are treated like any other BDC, so they have to make all their Exchange Act filings and comply with the Investment Company Act.
So let's go through the advantages in maybe a little bit more detail.
Okay.
And so, you know, how do they actually raise their funds?
As I said, they raise their funds through the private placement process. So it's a private placement memorandum, and the investors are limited to accredited investors, and they make a capital commitment to the BDC by signing a subscription agreement with the BDC.
So that's almost like a LP fund.
Exactly.
And as far as the liquidity, maybe a little more detail about how they get out of the investment, and then how the fees are structured.
For liquidity, the documents generally state that there will be a liquidity event within a set period of time, and if there isn't, then the BDC will wind down. And liquidity events can include an exchange listing, or with proper relief and approvals, a merger or a spinoff.
And is one of the advantages the time frame, how long it takes?
Absolutely. The process to raise and launch a private BDC is significantly shorter than the process for a public or non-traded BDC. A Form 10, which is the main document that's filed with the SEC for a private BDC, can be effective in as little as 60 days. And because it's not listed, there's no need to deal with the exchanges for the listing process.
And what about the types of filings?
The Form 10 is the filing that's needed to register the shares under the 1934 Act. Obviously, you need to file your N54A to become a BDC, but unlike in the non-traded world, there are fewer obligations for state filings. You don't have to complete the blue sky registration process, which requires a review by all the states. Instead, you make a Form D filing both at the federal level and with the states. And the Form D, unlike the blue sky filings, is a notice filing.
Right, so I'm just comparing it again to the non-traded world. You may very well have to go to 50 states and have a substantive review. And here you're talking about just a notice filing in those states.
Exactly, and usually it's very similar to the notice filing you make with the SEC, so it's just duplicating information.
Great. So, but and one of the advantages is, from my understanding, and the reason it's been attractive is because of some of the tax issues around it. David, maybe you could talk to us for a minute about the tax structure.
Sure. One of the primary drivers of the growth of private BDCs is the tax advantages that are offered to them vis-a-vis a typical private fund, which is classified as a partnership for U.S. tax purposes. Typically, in particular, it's advantageous for non-U.S. investors and tax-exempt investors. Taxable U.S. investors will generally be more or less neutral between the partnership structure and a structure involving a private BDC, but there's significant potential advantages for non-U.S. investors and tax-exempt investors, particularly where the underlying strategy is investing or originating debt in the United States. Typically, non-U.S. investors are subject to tax on any income that's effectively connected with a U.S. trade or business. That may include income from debt origination activities. That's usually thought to be a trade or business as compared to other types of investing. Non-U.S. investors are also subject to U.S. withholding tax on dividends and interest, although those are subject to certain exemptions, particularly in the case of interest, generally portfolio interest exception, which provides for zero interest expense, zero withholding. Tax-exempt investors are generally exempt from tax, but are subject to tax on unrelated business taxable income. That usually excludes interest income, and so generally that part of the interest income fund is not a problem for them. But many private funds that focus on debt, originating debt, use leverage in order to enhance the returns of the fund, and that causes the underlying income that would otherwise be exempt to become unrelated business taxable income for those investors. And if those investors invest through a private fund that's classified as a partnership, they typically they're treated as if they engaged in those activities directly, and so that can result in the non-U.S. investor being subject to U.S. income tax, and the tax-exempt investor having unrelated business taxable income. So how does the BDC structure relieve that? The BDC is a corporation for U.S. tax purposes, and so effectively acts as a blocker and cleanses both the ECI element and the leverage element of the underlying investments, so that those activities are not treated as being deemed engaged in by the tax-exempt or non-U.S. investors. As a result, neither the tax-exempt investors or the non-U.S. investors are going to be subject to U.S. income tax on their investment in the BDC. Additionally, from the perspective of the non-U.S. investors, although a typical corporation would be subject to 30% withholding tax on dividends paid to the non-U.S. investors, a BDC that qualifies as a RIC is eligible to pay certain dividends without the imposition of the withholding tax, and those include interest-related dividends, short-term capital gain dividends, and long-term capital gain dividends. As a result, it becomes a very tax-efficient structure for non-U.S. investors, tax-exempt investors, and generally a tax-neutral structure for U.S. investors, and so becomes a favorable tax vehicle in order to engage into a typical debt origination fund.
I'm sorry, David. My understanding is that even though you've given us a great explanation, people have not been able to hear you. Could you move down to a different mic, and we can try and maybe you can go through that at a more top level, because this is critical to the structure. So maybe just talk about the last, when you were talking about the...
Sure. Just to highlight the advantages again of the typical structure, providing that the BDC qualifies as a RIC for tax purposes, the BDC RIC acts as a corporate blocker for UBTI and ECI, meaning that neither of those type of investors will be subject to income tax on the underlying income of the fund. And that non-U.S. investors are able to receive dividends from the BDC RIC without the imposition of a 30% withholding tax, provided that those dividends are attributable to interest, short-term capital gains, or long-term capital gains, thus making it a very tax-efficient vehicle and a reason why we've seen an enormous growth in the private BDCs.
Great. So just to maybe say that in corporate speak as opposed to tax speak, you would not need an onshore offshore structure and any kind of season and sell in order for a foreign investor to be involved with a fund that uses leverage.
That's right. This eliminates many of the trade-offs that you would otherwise have to engage in order to make the vehicle tax efficient.
So you can get rid of some of that complexity. You just have an investment straight into the corporate structure, and as you said, it creates a blocker effectively.
Correct.
So just to, we've run through some of the advantages, but I thought it might be worthwhile to delve a little bit more deeply into some of the areas that and focus on some of those differences. So, Kristen, maybe you can walk through and talk a little bit about what's the process to begin a capital raise for a private BDC.
Absolutely. Similar to raising a regular BDC, you start by organizing the entity. Typically, the entity is formed in either Delaware or Maryland as a corporation. Next, you would have to file a registration statement under the 1934 Act with the SEC. This is on Form 10, and the Form 10 registration statement is required because in order to make an election to be a BDC, you have to have a class of securities registered under the 34 Act. You would also need to prepare a private placement memorandum and a subscription agreement for the investors to enter into with the company.
So you don't need a registration statement, a Form N2?
You do not need a Form N-2. The private placement memorandum is the document that the shares are sold off of, and it would contain substantially similar information to what you would see in a Form N-2 so that the investors are making an informed decision.
Right, so it's still a capital raise. You're selling securities, so you still need a document, either an offering circular or PPM, in order to sell those shares, most likely.
Exactly.
And then as far as the review, so the SEC is not reviewing the PPM, but they are reviewing the Form 10.
Yes, the SEC does not review the PPM, nor does the PPM get publicly filed, but the SEC does review and comment on the Form 10.
Right. And just to maybe say it one more time, is that this still is a transaction or capital raise that has only accredited investors. You really can't go out, similar to a non-traded where there's no accredited requirement. You may have other state requirements, but in this context, this is accredited investors.
Yes, it's accredited investors only.
And so do you have a, advisory agreement? What are some of the other requirements that go along with starting up the process?
Just like with a public or a non-traded BDC, you have to seek approval for and enter into an advisory agreement. The advisory agreement has to be approved by a majority of the BDC's independent directors at an in-person meeting, and the approval process must be done in accordance with Section 15C of the 1940 Act. The BDC also has to comply with all of the other federal securities laws, obligations, and requirements, all of the 1934 Act filings and 1940 Act requirements.
Right. And we'll go into those a little bit, but those are no different than any other BDC out there. That you don't get a buy in order just because you're designated as a private BDC or you're raising your money privately.
Exactly. Even though it's a private BDC, you're making a lot of public filings.
Right. So, and then just to go on to, a little more deeper into the process, do you usually have some type of a placement agent or underwriter, or is it done directly?
Well, we've seen it done both ways. Placement activities may be conducted by officers of the BDC or its investment advisor, or a placement agent may be engaged. When there is a placement agent, sometimes the advisor actually pays the placement agent fees, but the fees may also be paid by the investor.
Right. So this is really somewhat tracking the listed BDCs, where the advisor sometimes will pay a piece or a percentage. Okay. And so we mentioned accredited investors. What kind of accredited investors have we seen?
We've seen a lot of high net worth individuals, as well as family offices, pension plans, and institutional investors that may be based in the U.S. or abroad.
Right. And then you mentioned the subscription agreement. Does the subscription agreement look just like any other one that you'd see in a private offering or maybe in the non-traded world?
The subscription agreement includes different information than you would see in the non-traded world only because of the capital call process. So it gives all the details of when a company may call upon the investor's committed capital and how the company would determine the number of shares that the investor would receive.
Right, and we've already mentioned the reporting requirements for the company, but the reporting requirements for a shareholder or an investor are substantially similar as well.
They are. So even though it's a private placement, the investor still has to comply with Sections 13 and 16 of the 1934 Act, which means that if they have a greater than 5% beneficial ownership in the company, they have to file either Schedule 13D or 13G. And if they go over 10% beneficial ownership, then they're filing Forms 3 and 4.
And we've talked about the capital call process, but maybe you can give a little more detail around that. How would the private BDC draw down those funds?
The private BDC would, when they had an investment opportunity or decided that they needed additional funds, they would send a notice to all of their investors. Generally, the investor has 10 days notice. And at the end of that 10-day period, they're required to fund a portion of their committed capital. Generally, the notice goes out to all investors, and then they fund the capital and receive a number of shares, usually based on a recent net asset value.
So very much like any other type of drawdown or committed capital fund in the LP world or private equity world.
Yep.
And then what about the fact of when you start a BDC, you've got a fair number of organizational expenses that you incur prior to basically acquiring any investors. How do you share those among the investors?
In a structure where there are capital closings over a period of time, you don't want to disadvantage the initial closers, so you can adjust the purchase price in some closings for subsequent investors so that they pay a pro rata portion of the BDC's initial organizational expenses. And you can also require investors that come in subsequent to the initial closing to make a catch-up drawdown to ensure that eventually all investors will have contributed the same percentage of their capital commitment to the BDC.
And we've worked through some of these issues, and the way we're portraying this is how it's been done. I mean, you could actually, we've seen some morphing or changing of how people are doing this. This is just the way that is the most common.
Yep, there's a lot of optionality here, but we're talking about the most common way.
And then just to talk a little bit more about the liquidity events, maybe you can describe how those are structured or how those are discussed in the documents.
Yes, so the documents generally say that after a set period of time, if there has not been a liquidity event, then the BDC will wind down. And liquidity events can include an exchange listing, which we've seen. And for an exchange listing, the BDC would file a 33 Act registration statement, list its shares on the stock market, and proceed as a public BDC. Other liquidity events could include a merger into a public BDC or a spinoff.
Right, and what's the period of time that the BDCs usually have until they have to do a liquidity event, or that they've put in their documents? Isn't it about 5 to 7 years?
It is about 5 to 7 years. Often we see 5 years subject to extension at the board's discretion, up to 2 additional years.
Right, and it's still somewhat of the board judgment. Is that the?
Absolutely. So the board can decide when during that 5 to 7 year period to undergo a liquidity event. They can evaluate market conditions and decide which liquidity event makes most sense for the company and its shareholders, or they can decide to proceed with a wind down.
Right. And if you wanted to look into kind of a spin-off transaction or something along those lines, you might be in the world of needing to do an exemptive app or something along those lines. It's something you have to look into, and there may be a shareholder approval and board approval requirement. Same process you would for almost any other type of extraordinary transaction.
Yes, the spin-off would most likely require exemptive relief as well as board and shareholder approval.
Right. And David, what would the tax be on something like a spin-off?
Generally, the spin-off transactions are going to be a taxable transaction that generally won't qualify for the tax-free treatment of a spin-off. But with a typical debt fund, we would generally expect that the asset value is relatively close to the basis, and that there likely isn't a lot of gain to be recognized.
Great, and then just some more terms that we've seen in some of the private BDCs. Is there anything special about the advisory fee or anything that's contemplated differently between the pre-IPO or listing stage or sale?
We have seen some private BDCs structure their advisory fees so that it is different prior to a liquidity event than it would be after a liquidity event. This allows for a potentially lower advisory fee during the BDC's ramp-up period, and then after the liquidity event, the BDC can charge a different or greater fee.
Right, and that can be structured several different ways. You could the advisor could decide to do a waiver or something along those lines. It's just something that we've seen in a couple of these, but you'd have to disclose all of that kind of up front so everybody was aware of what was happening during the various phases.
Exactly.
And then the independent board members, have we seen anything different there as far as the payment of the fees?
Fees paid to independent board members can differ before and after a liquidity event. Sometimes board members get paid greater fees for being on the board of a public company. We've also seen sort of a sliding scale of fees based on the assets of the BDC.
Right, and that's another concept that's taken from the non-traded structure, where there's sometimes volume creates a higher fee level for the board level, just because there's more potentially more work, I guess.
It's the same concept, yes.
Right. And then what about any other board approvals? Is there? I mean, they're going to be involved in. We've already talked a little bit about they've got to vote basically if there's going to be a liquidity event.
If there's going to be a liquidity event, the board would vote for that. Depending on the liquidity event, the shareholders might also vote. And generally, even if the liquidity event was an exchange listing and shareholders didn't have an explicit vote, they would have liquidity after the event, so they could sell their shares if they didn't approve of the liquidity event.
Right, and there's been, I believe there's 2 BDCs that have gone from being private to being public, right? There was one a while back, and then the most recent one that I mentioned earlier in the call. You could technically just have the BDC continue on and not have necessarily a liquidity event if you provided for it up front.
If you provided for it up front, you could have a perpetual private BDC.
But we haven't really seen any of the BDCs go through anything like a liquidation or anything along those lines at this point.
None of the private BDCs have wound down, and the only ones we've seen go through a liquidity event are the 3 we mentioned, which have made 33 Act filings and done exchange listing.
Right, and then just going over to talk for a minute about a private BDC board. The board is effectively the same requirements as being any other type of BDC, right?
Yep, the board must consist of a majority of independent directors, and sometimes we've seen where an advisor has more than 1 BDC, some of the board members will actually overlap.
Right, and you need to just check your regulatory structure if you're part of a platform, whether that's whether you can do that or not.
Correct.
And then is there anything else that has been borrowed on the private BDC area from the private equity world?
We have seen some significant investors seek nomination rights.
Right, and the nomination rights in a 40X structure, you can't necessarily have an investor appoint a board member. You have to have the shareholders vote. So in that context, you could have a nomination right, which the board would still have to sign off on.
Yeah.
And then anything else? Are the fiduciary duties any different for a BDC, a private BDC's board?
Are not at all different. So in addition to independence, and we touched on the board has to, a majority of the independent directors have to approve the advisory contract at an in-person meeting. There's also a compliance element. The board must approve the BDC's compliance program and the chief compliance officer, and the board approves quarterly evaluations as well.
Right, so the next slide really just augments what we've already talked about, and then we're going to talk a little more about the compliance and regulatory framework. So let's just go on to the next section. We've talked quite a bit about the periodic reports, but basically everything applies to a BDC. You may be able to, or private BDC, excuse me, you may be able to rely on some emerging growth companies, release, that type of thing, but really it's the same.
It's the same as any other public BDC.
Right. But since you're not doing any type of an N2 here, there is no confidential filing that you would take from the job growth amendments, right? A Form 10 is public.
Correct. There's no ability to file a Form 10 confidentially.
So, and then you've got the financial statements, although you're kind of ramping up, so the financial statements aren't very significant from the beginning. They're pretty much the same requirements apply here that would apply to any other type of BDC.
Exactly.
Maybe we can spend a minute talking about the 40 Act requirements. Before we do that, if anybody is getting CLE credit, the CLE code is a liquidity event. So anybody who needs that will know what I was just talking about. Sorry for the pause in the discussion. So, Kristen, we've already talked about the independent board that you need to have in place. What are some of the other 40 Act requirements
They're the same again as any other non-traded or traded BDC. So the BDC needs a custodian, which requires it to maintain its securities and similar investments in the custody of a bank, essentially. It has to have in place a fidelity bond and also a code of ethics.
Right. It's not on the slides, but we have found that in this context, you do have to have a transfer agent in place, one that's regulated by the SEC.
Yes.
Right. So just going on to talk for a minute about the other requirements. What about some of the requirements about pyramiding or affiliates? Do those all apply?
Yes, the anti-fee pyramiding rules apply, and that limits the amount of the extent to which a BDC can invest in an investment company, and it also restricts the ability of an investment fund to invest in the BDC.
And then are the BDCs also required to keep the books and records that you would for any kind of 40 Act company?
They have the same bookkeeping and records requirements as any other BDC or 40 Act company.
And then you'll probably know the answer to this one because it goes the same. The Chief Compliance Officer, the board has to appoint the Chief Compliance Officer. So you have to have a compliance program in place from kind of day one?
Yes. From the beginning of when you file your N54A to become a BDC, you need a Chief Compliance Officer, you need a Rule 38A1 compliance program in place.
Right. We haven't really focused on the advisor, but a BDC has to have a registered investment advisor, and as a result has to have a compliance program in place.
Yes, any investment advisor must be registered under the Advisors Act and have the appropriate compliance policies in place.
Right, so you may have an advisor that's already registered. You may want to do a new one. It really depends on the facts and circumstances of your management team or your sponsors.
Yep, we've seen it both ways.
And then there is, in addition, regardless of the time frame, whether you're still operating private and raising funds, you could still be examined by the SEC. There's really no difference here either.
Exactly. Again, it's just like a public BDC, you could be examined at any time.
And David, maybe you can just talk for a minute on the RIC requirements and maybe how that's impacted with the private structure.
Sure. The basic requirements for qualifying for a RIC are exactly the same as a public BDC or any other entity trying to qualify as a RIC. The three major requirements are the minimum distribution requirement, the asset diversification requirement, and the source of income requirement. The minimum distribution requirement does cause a little difference between a typical private fund and a private BDC because while you're calling capital, you're also required to make distributions in order to satisfy the minimum distribution requirement. The asset diversification test is one that can cause some issues for private BDCs, particularly in the ramp-up phase where you have a limited number of assets and you haven't drawn all of the capital from your investors, so you don't have a lot of cash on your book allowing you to qualify. That's one you need to plan for and be carefully monitoring from the outset because that applies beginning your first quarter after you become a BDC. The source of income doesn't generally create any additional issues for a private BDC compared to any other BDC.
Great, and just to talk for a minute, when a BDC has, when they're starting out, there may be a period of time that they've got to adjust because they're ramping up and they've got to still meet the requirements, right? So the timing of when you choose to be a RIC, you've got to be careful with.
Sure, for a couple of things. One, the timing you make your election is important. Because you need to, in order to qualify as a RIC, you have to be a BDC every day of the taxable year. But then also you have to start qualifying for these requirements immediately, and it applies beginning your first quarter, the end of your first quarter of your year. And so, for example, you may not want to start your period running on March 30th because you'd have to comply on March 31 with the diversification requirements, whereas if you begin on April 1, you'd have until June 30th to comply with the requirements.
Great. And then maybe just to finish off on the other compliance pieces, Kristen, is there the same issues around NAV that there are for other BDCs?
There are. So the private BDCs may not sell shares below net asset value without shareholder approval.
And then if you're looking at a private BDC, you probably have to analyze the same type of issues around exemptive relief. What are some of the pieces of exemptive relief that you might consider looking into?
You might consider exemptive relief to co-invest with your affiliates, ownership of an investment advisor, issuance of restricted stock, and stock options.
Great, and then and that brings us to the end of our slides, but maybe we can talk as far as the capital raising process. The capital raising process really is can go for whatever period of time you designate. I mean, there's not necessarily a requirement. It's generally longer than, for example, a listed structure, which is generally a couple months, and similar to a private fund, a private BDC can go for a couple of years, that type of thing.
Yeah, the officers of the BDC and/or a placement agent can be, essentially marketing the PPM and soliciting investors for any period of time. And
so I just before we go into our conclusion, I'm getting a number of questions, so I'm going to start reading those off, and we can I'll throw them out to the group. Some of them pertain to private BDCs, and some of them pertain just to BDCs. So, Kristen, why do you think certain sponsors are choosing the private BDCs over the traditional private equity LP?
Over the traditional private equity LP. There are benefits. I mean, I'll let David speak to the tax benefits, but I think that it's attractive to the investors to be investing in a public company. There's additional regulation there, oversight by the SEC, and the investors have more visibility into what the BDC is doing versus a private fund that is not making SEC filings.
Right, so I mean, you have the comfort of being a reporting company for one, and then as you have that comfort and the fact that you have the 40 overlay, the compliance that we've been talking about, and then you have effectively the offering documents. But with all that, basically, as far as the structure, you don't have that in LP. Basically, it's really structured however the platform or the managers want to put it together.
There are significantly fewer restrictions in the true private fund world, and so the additional restrictions do provide comfort to an investor in a private BDC.
Have we found that the private investors understand what a BDC is?
It varies. A lot of private investors, I think, are surprised by the public filings, particularly the Section 16 and Section 13 requirements. We've seen a lot in the early stages that they're used to a greater ability to negotiate terms.
Right, and from a tax perspective, we've seen that they often come with the same type of side letter requirements that they would for a private fund when they're not really applicable to BDCs. So there is some education necessary on that. But it is probably the tax advantages that are driving the most of the growth in the private BDC market, because of the ability to do debt origination activities without incurring ECI or other large structuring activities to get around that.
Right, so all of these items that we've talked about, one, you have to be really careful when you're structuring. So, I mean, you really do need to look to see if you're a part of some type of a platform. Do you have issues that you need to deal with up front? Are there affiliate questions? Is there any kind of relief that you might need? What would you do from a standpoint? This is another question that came in about what's the status of the RIC dividends, David, and they're qualifying for the 20%. That applies to REITs.
Yeah, part of the new tax legislation that was enacted last year provides a deduction of 20% for certain pass-through income of individuals. That pass-through income was defined to include REIT dividends and did not include RIC dividends. We and people who advocate on behalf of BDCs are aware of this. and have attempted to get that in. Whether that will get in or not is unclear. It's going to be difficult to make any additional changes to the tax law in terms of getting an agreement, because the process was done through budget reconciliation to limit the ability to have Senate filibusters, and so trying to get additional changes through is going to be difficult.
Right, there's really not much appetite for that these days, right?
Right.
And then there's another question on the asset diversification and whether that test is the greater of 50% or is it the 70%? Maybe you could just talk a little bit about diversification.
Sure. Those are two different requirements. There's a BDC regulatory requirement for 70%. That's completely separate from the RIC requirement, which is that 50% of your investments have to be in certain good RIC assets, which are generally cash equivalents, government securities, securities of other RICs, and then other securities that you own no more than 5% of your total assets in securities of that issuer, and you own no more than 10% of the voting stock of that issuer. So that 50% of your portfolio has to come under that limitation to qualify as a RIC.
Great, and we've mentioned that there's been obviously a number of these that have been, there's about 20 of them or so out there, and since 2016 there's about 12 that have been raising money and at varying levels, but only 3 have actually gone through the process. 2 or 3, depends on how you count. When you characterize these, some people may be considering something private than private BDC, or what we call private. Is, it depends on how it's all the money is raised. But I mean, the story on the private BDCs and the effectively how popular they're going to be in the future, whether the listed market opens back up more, is really yet to be seen. I mean, one of the things to keep in mind is that the listed were very popular for a long time, and then the non-traded basically within a couple of years met the same numbers or very close to. So now you've got the private. The fact that the BDC structure allows you to morph into these different areas as you can do different type of transactions is one of the reasons that resilience, I think, is why we're talking about it now. So which, I don't know that there's necessarily a better structure. It just means you need to look at it, see how it applies to you, and determine whether it makes sense. And who are your investors, who are your managers, and how do you want to approach the market, and how do you want to ultimately provide liquidity to your investors. So there's certainly lots more to talk about the private BDCs, but this at least gives you a little bit of a taste. I've actually gotten several questions about BDCs by themselves. And I guess we can try and talk about them for a minute more, but we may very well schedule another call just to talk through some of these. One of the questions that came up is basically can you qualify as a BDC if your capital source is buying equipment and not securities? The equipment is producing a cash flow through a lease-like arrangement. I mean, at the end of the day, a BDC really is a fund. It is you have to have a portfolio of securities. We really didn't talk about the fact that the 70% need to be in eligible portfolio companies, and then you've got 30% that could be in other types of investments. But at the end of the day, you need to be investing in securities. When you're talking about leases, whether it's really a lease or whether it's a loan, really gets much more complicated, and what I would suggest is that you're going to have to spend some time looking through that. If it really is a lease, that may not necessarily qualify, but again, that's something that has to be, it's a facts and circumstances test. So for that question. Another question was to talk about co-investment limitations and SBIC subsidiaries. As far as co-investment limitations, I don't know that I would necessarily say it's a limitation. The 40 Act has a blanket prohibition, but there is a number of co-investment exemptive apps and orders out there that all follow a very core number of conditions that allows you to co-invest among funds, and they're primarily related to including the board as a gatekeeper and making sure that there's no advantages given to a private fund or other fund over the BDC, but there's about 13 of those. So the co-investing can be done. You just have to make sure that you're providing the right type of compliance and board approval process. And happy to go through that with whoever asked that question in more detail. SBIC subsidiaries there's about 15 SBIC subsidiaries underneath BDCs. The SBICs were the forerunner of BDCs to a large extent. A lot of the exemptive relief that SBICs had before the 1980 amendments were actually what the legislation that started our BDCs included. So the family of SBICs, like I said, were a forerunner. So it's a natural progression that in this day and age that under the BDCs you actually have an SBIC subsidiary that allows you to have a little bit greater leverage just because of the SBA regulation and the SBA rules. It's an application process that you've got to go through, and like I said, there's about 15 of them out there today, and they've been approved in the last couple of years. I think that actually BDCs are about 20% of the SBA's portfolio. It's an arduous process to go through to get a license, but you do basically have favorable terms on some the debt securities that are provided to the SBA. So it's very commonly used. There's no reason that it can't be used in a public BDC structure. In a private BDC or a non-traded BDC, it's a little more complicated because what you're relying on as far as the investors that are diversified, you're looking to the public shareholders from the perspective of a listed company. Depending on how many shareholders you have in either a non-traded or public, non-traded or private, you may have some issues. So the SBA has looked at a number of these applications and are still, I think, grappling with some of those issues as far as whether the licenses will be granted. So if you know the SBA program overall, it's the licensure level has been reduced. So it's, as I said, there's no prohibition, but it's a process. And happy to discuss that with whoever has asked the question. Anyway, I think that brings us to the end of our questions. If I didn't answer one of them, please feel free to call any one of us to talk through that. We'll make the slides and the presentation available, so hopefully this was helpful, and everybody has a great afternoon. Thank you very much.